up if that's showing properly. Lovely. Good. Well, as I say, welcome everyone. I am a senior associate with Irwin Mitchell. I have been doing this job far too long, to be honest, about 20 odd years now. I've been working in the field of private client, trusts, estate planning and so forth. And relatively recently, myself, our youngest son, he's 7, he's now on the SEN register at school, very mild ADHD. And it's given me more of a personal insight into the kinds of challenges my clients experience day to day. As I say, it's very, very mild. He did turn to me the other day as I was trying to explain something to him, and he said to me, "Daddy, please stop talking. You're making my brain hurt." I very much hope today I won't make your brains hurt. And what I want to try and do is demystify the area of trusts, of benefits, and help you understand the options that are available to help you protect and provide for your children now and in the future. As Kate says, very happy to answer your questions by email afterwards. Do please put questions in the chat as we go through. There is no such thing as a stupid question. There really isn't. If there's something you're thinking about, I can guarantee you 50% of the other people on the call are probably thinking the same thing, and I will have heard these questions before as well. You've got my contact details and a ghastly picture of me on the screen there. As I say, these slides will be shared afterwards. Do feel free to reach out and make contact, because it is a complicated area, and I can guarantee I won't address all of your questions today. So what will I be talking about over the next hour or so? I've put a little bit of agenda up there. As I say, do feel free to ask questions. It might lead us on to some different topics, but I want to start really by talking about mental capacity and indeed sort of vulnerability. What is it? What does it mean in practical terms for you, for your children? I'm going to say a little bit about lasting powers of attorney. Now, depending on your child, lasting power of attorney may not be relevant for them, and I'll come on to why in due course. I'll talk a bit about deputyship as well. That might be a term that you've come across. It might be something you've got in place for your children already. But most importantly, kind of the crux of really what I want to talk to you today about is trusts and how they can really help your children, help you provide for children, protect them. Definitely, slightly obviously, I suppose, as a private client lawyer, I am going to be talking about wills. They are really, really important documents. If you don't have one, I hugely recommend you get one in place, particularly where you've got a child with educational needs. It's so important. It's going to be really one of the major documents that you can use to ensure your child's future. Normally at this stage, if I present in person, I'll ask people to put their hands up and say who here's got a will. And normally only about 25% of people put their hands up. So don't feel bad if you don't have a will. You know, you are not alone, but it is something really important to put in place. And then I'm going to round up with the role of trusts and how they work. I'm going to try and boil it down. Trusts are a complicated area. I mean, they've been around since the Crusades, so you know there's a lot of legal history behind them. But they are. I try and bring it down to very basic concepts, and then I'm going to wrap up with a case study, which hopefully will bring this to life for you. So I hope that's okay. It will be a bit of a rattle through, but I do ask questions as we go through. So kicking off straight away, practical issues on loss of capacity. What does it mean if a child lacks mental capacity? And it means various things. I mean, first off, and it seems odd, you know, when your child becomes an adult, when they turn 18, you've actually got no automatic authority to take decisions for them, be that in the health field with doctors, with social services, or on the financial side. You can't manage their bank account for them. The only exception to that are benefits. You can still remain someone's appointee. You can still claim benefits for them, but you can't technically manage their bank account. You can't make a will for them or do anything like that. If someone had capacity and they lose it, it means their bank account could be frozen. The bank can turn around and say, no, sorry, no one can access this account until you've got a power of attorney or deputyship in place. If they own a property and they're unable to understand the concept of selling a property or purchasing one, that can't be done either. They can't instruct investment managers, stockbrokers, and so forth. They can't make a will. They can't change an existing will. So financially, property and affairs, very little can be done if someone lacks capacity. On the health and medical side, health and care side, yes, decisions can still be taken for an individual who lacks capacity, but those decisions will be taken by the medical professionals or by social services. The role of the family really then is consultee. You should be consulted about the decisions, but you have no right to take those decisions for them. So loss of capacity is a really important thing to look at. It's important to understand what it means if someone is judged to lack capacity. And so I wanted a quick word on lasting powers of attorney. If an individual has mental capacity, they can make a lasting power of attorney to appoint someone to act on their behalf. The key point about this, though, is it would be your child's decision whether they want to make a power of attorney or not, and who they want to appoint. You know, if they're like my son, they'd probably say, no, Daddy, I don't want you managing my finances. You won't know what to do. You'll make it too complicated. But the key thing is they must be able to understand what it is, what a power of attorney document is, and the power it gives to the person they want to appoint. So it's actually quite a high level of, quite a high test of their mental capacity to decide whether they can do this. I'm conscious I'm talking about the test of mental capacity and so forth. I am going to cover that in a bit more detail as we go through. So there are two types of mental power of attorney. There's a financial power of attorney, which kind of does what it says on the tin. It enables the attorney, whoever they've appointed, to manage bank accounts, sell properties, invest assets, pay bills, do all the things an individual would do for themselves in terms of their finances. It doesn't enable you to make a will for someone. If someone lacks capacity and they haven't made a will or can't make a will, only the court can do that on someone's behalf. The health and welfare power of attorney, well, that comes down to medical and care decisions. Really, as I put up there on the screen, you can decide where someone should live. Should they be in sheltered accommodation? Should they stay at home with you? Should they be in a care home? You can determine who they see in terms of friends and family members. You can agree the care they should or shouldn't receive. You can refuse medical treatment on their behalf. But quite importantly, you can gain access to their personal information. And I find a health and welfare power of attorney is really helpful when it comes to dealing with social services. You may have experienced this. You may find that the shutters come down when the child turns 18. You're told, oh, we can't talk to you anymore. You've got no standing. It's really important to have a health and welfare power of attorney in place because it gives you that standing to request information. Strictly says a parent, you should be consulted anyway, but with a lasting power of attorney in place, it makes it much harder for anyone to refuse that information. One of the best bits of advice, best practical bits of advice I can give really for a child turning 18 in terms of the health and welfare side is make friends with someone at social services if you can. I know it can be difficult, but if you get a trusted contact there, someone you really get on with, it can help enormously. It can help open doors. Talking a little bit more, as I say, about powers of attorney, making them, as I say, it's this test of mental capacity. And this test applies not only in making powers of attorney, but it sort of applies a bit before that. Can someone manage a bank account? Can someone pay bills? Can someone decide what medical treatment they should have? And the law sets down this test that comes in two stages. The first stage is to say, does the individual have an impairment of or a disturbance in the functioning of the mind or brain? That's not my wording. That is the wording from the statute. It's awfully grand, but what the hell does it mean? It's basically saying, does someone have something potentially physically wrong with their brain, which could be something like dementia or something like that, where there is a disease going on in the mind? Or is it something that's affecting their cognitive process, affecting their ability to take decisions, affecting the mind? And again, that could be SEN. It could be diagnosis of ADHD. They can't concentrate long enough to take a decision. There is something going on. It could be temporary. It could be that they're drunk. That is a disturbance of the functioning of the mind. If you've ticked that box, you move on to the second stage, which is sort of 4 questions you ask. First, can the person understand the decision that needs to be taken? So in this case, can they understand what the implications are of making a power of attorney? Secondly, can they retain the information they need long enough to form a decision? In this case, to decide to make a power of attorney. Really importantly, and this is often where children with SEN fall down, can they weigh all the factors they need to consider to reach a decision? And that might be the problem. They might not understand the risks associated with making or not making a power of attorney. And finally, can they communicate their decision? And this can be with assistance, can be with a light writer, diagrams, using toys, whatever it might be, to say, yes, they do, or no, they don't want to make a lasting power of attorney. Importantly, a lasting power of attorney can only be made once the child reaches 18. And say it's their decision, they're the one who needs to provide instructions. It's not something a parent can do on behalf of a child. Absolutely, you can make your own lasting powers of attorney, and I'd really encourage you to do so. If you haven't got a lasting power of attorney in place yourself, definitely well worth doing in case something happens to you in the future. You need to make sure your own finances, your own care can be taken care of. Assuming you've got over that hurdle and the individual does have capacity to make a power of attorney, then the forms themselves are relatively straightforward. Anyone can go on the internet and download them. We offer a lot of advice on making powers of attorney, and really where our role is that first step, deciding whether someone's got capacity to do it, and then making recommendations about what you should put in the power of attorney, who you should appoint. Very often people say, yeah, I'm going to appoint children or parents as attorneys, which is fine. But do those children get on? Might there be a conflict of interest? And I'll talk a lot more about what attorneys and deputies can and can't do shortly, but a lot of thought really needs to go into who is the right person to be an attorney. I did an article recently on this on LinkedIn, which I should share really, which gives some top tips about what you should be thinking about in terms of who to appoint as your attorneys. The key thing is, before a power of attorney can be used, it must be registered with the Office of the Public Guardian. That's sort of like the attorney deputy police, if you like. They keep a register of all lasting powers of attorney that have been made, and they can intervene. People can complain to the OPG if they think the attorney's not doing a good job or not acting in the individual's best interests, and the OPG can investigate. It's a fairly long-winded process doing the registration. It takes at least 2 or 3 months, mainly because the OPG is so backed up. They get about 7,000 applications a week to register powers of attorney. And I was chatting to them recently, and they said they really want to move building, but they can't because they've got 1.2 kilometres of paper stacked up in their offices. So they are really overwhelmed at the moment. So it takes a long, long time to get LPAs registered. But the OPG will look at powers of attorney when they're sent to them. They won't check them for factual accuracy. They won't check dates of birth. They won't check addresses or anything like that. But they will remove terms which they think are invalid, or they may tell you if the power of attorney isn't legal. So it's really important to get that advice up front if there are particular terms you want to put in the power of attorney to make sure it gets through that registration process. Acting as an attorney, I think this is really important, and many of these comments also go hand in hand with acting as a deputy, and I'm going to talk about a deputy in a second. The starting point for acting must be to assume that the individual has capacity. You can't say, just because I'm attorney, I'm going to take all decisions on their behalf because they lack capacity. Capacity, it is tested at the time the decision needs to be made and on the basis of the decision that needs to be made. So it's not black or white. It's not this person has capacity or they don't. It may be they are perfectly capable to pay a gas bill. Very low tester capacity there, but they don't have capacity to decide to sell a house. I had a case some years ago, a lovely lady who struggled with the concept of money and also loved to play bingo. and spent quite a lot of money playing bingo, to be honest. And she could get the idea that if she went along to the bingo hall with 20 quid and spent that all on tickets and everything, she wouldn't be able to buy a takeaway that evening. She could get that, but she couldn't get the concept that if she took up £200,000 down to the bingo hall and used all that, she wouldn't be able to stay living in her house. And it was a really interesting capacity decision, because it was at some level of money she didn't have capacity, but she did at lower ends, didn't at the higher ends. So that's the key thing. You've got to assume the individual's got capacity and then do that test. You've got to do everything you can for them to enable them to take the decision, you know, setting it out, breaking it down into bits, enabling them to communicate their decision. Only if you think this person doesn't have capacity to take the decision in question can you act for them, and then you must act in their best interests. And best interest isn't saying what would they have done if they had capacity. That is a factor. That is something you put into the decision-making process. You kind of got to weigh up the pros and cons. The classic is, should this person go into a care home? Well, the cons are, they may have said, I never want to go into a care home. But the advantages are, they will be well looked after, they'll be medicated, they'll be fed, they'll be in a comfortable environment. But you weigh against that it's kind of a closed environment. So, you know, you've got to do that balance sheet approach. You've got to weigh up what are the pros, what are the cons, and then decide in their best interest. And the really difficult thing is you've got to set emotion aside, which can be so hard when you're trying to take decisions for a child. There are some things attorneys can't do. You can't make significant gifts, you can't make a will for them, and you can't act if you are conflicted. And this is where attorneys often fall down, and so that's why a lot of thought has to be put into who are the attorneys at the outset. And I had a situation where a son was attorney for his mother. He was living in her house. That was his main residence. She needed funds to pay for her life, so she was taking out or he, on her behalf, was wanting to take out an equity release mortgage. But because he was living in the house, he could not consent to that mortgage. He was in a position of conflict. His interests of wanting to stay in the house conflicted with her interests of wanting to take out a mortgage that put his occupation at risk. And the mortgage company said, we cannot take his instructions as her attorney because he is conflicted. It might therefore be better, particularly if it's a parent-child situation where the child is living in your house, to have a third party also as an attorney on board. I say really important things to think about at the outset, and it's better to sort that out when the individual has capacity, because if their condition is progressive and they lose capacity over the years, you can't go back and change a power of attorney. Attorneys are also personally liable to people. It's not an open checkbook. If you make a mistake as attorney, if you deliberately spend down the individual's assets, you can find yourselves liable to the beneficiaries of the will, the local authority for care fees, revenue for tax, creditors of the estate as well. So you have to really choose attorneys who've got the financial nous, time, and be willing to take on the job. I don't want to scare anyone away from being an attorney. I do just want to say there are a lot of strict rules, so it's worth going into it with your eyes open. I said I'd talk about deputyship, how would you change attorneys if they died? So yeah, if an attorney dies, then depending on if you've appointed more than one attorney and depending how they're appointed, the co-attorneys would just carry on. So, you know, if mum and dad are appointed as what we call jointly and severally, that means they can act together or independently. If dad dies, mum can carry on her own. And or you can appoint replacements. So, you know, classic family situation, maybe you've got mum and dad as primary attorneys, they would act. But if both of them have died, you can have, say, brothers and sisters or a third party as a replacement who then steps into their shoes. But you kind of only get one bite of the cherry. You've got these two levels, primary attorneys and replacements. You can't have replacements for replacements. So again, you've got to think about who's going to be the right people to be attorneys way into the future. You know, what are their age? You don't want to appoint someone significantly older necessarily than yourself, because they may not be around. They may not have capacity themselves to take those decisions. But really good question. Deputyship. So basically, a deputyship is needed where someone cannot make a power of attorney. They don't have the mental capacity to manage their affairs, and they don't have capacity to make a power of attorney, which in all honesty is probably most children with more severe needs. A deputy is sort of a court-appointed attorney. It is basically an application needs to be made to the Court of Protection, which is different to the High Court. It's a specific court that deals with individuals lacking mental capacity. And someone has to go to them and say, look, my son, daughter, whoever it is unable to manage their property and financial affairs or take decisions about their health and welfare. They need someone to do it on their behalf. I'm going to be that person. And you've got to produce evidence as to why you're the appropriate person. You've got to produce evidence also that you're an honest individual and not declared bankrupt, have never been convicted of fraud or anything like that, because the court is going to analyse very carefully, is this the right person to be their deputy? You can have joint deputies and joint and several deputies, so mum and dad being deputies for children, absolutely fine. But as I said on the slides, anyone can apply. And although anyone can apply, they need to show standing. They need to show they have an interest in the individual's life to be appointed by the court. But if there's no one in the family, there's no friends willing or able to take on the role, the local authority can apply to be deputy. Social services can and will do it, particularly if the individual's in sheltered accommodation or there's care fees that need to be paid and no one's got access to the bank accounts. Social services will take on the role, and they have a huge number of deputyships. Again, social services are a bit overwhelmed with the number of deputyships they've got. So, if your child can get a lasting power of attorney in place, that's kind of the gold thing, the really good thing you want them to be able to do. If not, you need to go to the court to apply to be their deputy. Again, deputy only applies from age 18, but it can take 6 to 12 months to get a deputyship through the court, so there's no harm in planning in advance. The authority of the deputy is often more restricted than an attorney. An attorney has quite wide-ranging powers, unless the donor of the power of attorney has restricted them in the document itself, whereas a deputyship's kind of the other way around. You've only got the powers that are contained in the court order, the court deputyship order. Normally, a standard deputyship order will enable you to manage bank accounts, invest money, pay bills, do all the sort of standard things. It will not normally automatically contain a right to buy or sell property. It probably will contain the ability for you to make gifts, but only limited gifts on specific occasions. So it's quite a restricted order. A deputy also has to buy an insurance bond that covers the individual in case the deputy makes a mistake or runs off with the individual's money. That's not the case with a power of attorney. So, if an attorney runs off with their money, then the individual is left trying to sue the attorney to get that money back. With a deputyship, there's an insurance bond in place. It might involve a court hearing. If you apply to be deputy, you do have to give notice to other individuals, at least 3 other individuals who might be interested in the person's financial position. And if any of them contest it, the court will need to decide who should be appointed deputy. Let's say it is quite a long-winded process. So let's say six months or more, quite commonly. So why is the deputy needed? Well, for all the things an individual can't do for themselves. So if they can't manage their bank account, pay bills, purchase and sell property, that's what the deputy/attorney would do for them. I've spoken a lot, really. I focus a lot when I'm talking about deputy about financial side. You can apply to be a health deputy. Again, like the power of attorney, they're two totally separate things. There's a financial power of attorney, there's a financial deputy, there's a health power of attorney, there's a health deputy. Financial deputyships are granted really to a penny, to be honest. They cost a bit more than that, but they are granted a lot. Health deputyships are very, very rarely granted. And the reason for this is financial decisions, as I said at the start, cannot be taken for the individual unless there's an attorney or deputy in place. Health decisions can and would be taken by doctors and social services. And the approach of the court is to say, well, why should we, the court, appoint an individual above social services, doctors, etc., when there's this framework in place already. So it is very rare for a health deputyship to be granted. You may say, well, hang on, this is bloody unfair. You know, I'm a parent. I've been looking after them for the last 18 years. I know their wants, their needs, their specific health requirements. But, you know, if it's working, if the doctor's already on board, if they're consulting with you, you know, the court's going to say, well, we're not going to interfere with that. It's working. The court may well grant you authority to take very specific decisions, urgent medical treatment or something like that. But generally speaking, health deputyship to take general health and care decisions, more often that would be granted probably for a traumatic incident. For example, husband and wife, where one of them suffers a suddenly traumatic injury that you know rendered them paralyzed or something like that, where the spouse is in that situation having to take a lot of decisions very quickly and then on a long-term basis. But I'd say unless there's a really overriding specific factor in your child's life, it's highly unlikely, unfortunately, the court will grant a health deputyship. But the financial deputyship definitely is something you should apply for. And the questions popped up here about, do we need to wait until someone's 18 to apply for a deputyship? It won't be granted until they're after 18, but there's no harm in doing the prep work beforehand. So there's a fair bit of prep work to do, you know, gathering information about their finances, putting the witness statement together to say, you know, I'm the right person to be their deputy because X, Y, Z. So you can certainly get things in place. And you probably want to be doing that maybe 3 or so months before they hit their 18th birthday. You can get the application lodged on their 18th birthday, hopefully then granted a few months later. So I hope that answers that query. So what I really wanted to dive into is trusts and wills versus deputyship, because a financial deputyship or a power of attorney is only needed if the individual's got money or assets. If they haven't got anything, you don't need a financial attorney. You don't need a financial deputy because there is nothing to manage. And often I find social services saying to parents, you need to apply for a deputyship, quick, get on with it. But actually, parents come to me and say, well, my son doesn't have anything. He's got his benefits, but I'm his appointee. I said, well, there's no point. There is no point in spending money applying to court or putting a power of attorney in place if there is nothing to manage. And this is the key thing, or key advantage about setting up trusts under your will or during your lifetime. What you do is, rather than giving your son or daughter money outright that needs to be managed by a deputy and will affect their entitlement to benefits, put it in a trust. You get to choose who the trustees, who the people are that manage that money for your child. There is no reporting required to the Office of the Public Guardian. There is flexibility. The trustees, and I will talk a lot about this, the trustees can decide how to use those assets for the benefit of your children. Okay, trustees can't take health and welfare decisions, but they can certainly influence those decisions because they'll have the money. They'll have the ability to decide what the funds should be used for. So you can, if you've got social services saying, well, we think this sheltered accommodation is going to be ideal, the trustees can say, hey, actually, we've got some money sitting here. We'd like to get something rather better, please. So I think it's really, this is why I hugely emphasize putting a trust in place under your will. So coming back to kind of the importance of wills, the starting point, so 25% of people say they've got wills, the others don't. They are really important documents. The three things they do is they give authority, they give certainty, and they give flexibility after your death. So an executor's authority comes from the will itself. The executor can start doing things straight away. They can start talking to the bank, put a house on the market, arranging a funeral. You can also appoint guardians of children under the age of 18 under your will. And that starts from the moment of death. Yes, the executors might need to apply for a grant of probate down the line. The grant of probate is only needed if a financial institution says, we want to see it. And commonly, if an individual's got less than 20 or 30,000 pounds in a bank account, a bank will happily hand that money over on the site of a will without needing to get a grant of probate. So, executors can actually do quite a lot from the start. It's also certain. You know exactly who's dealing with your personal items. You know who's going to be talking to the banks. You've got your funeral wishes there. You know what's going to happen. You know who's looking after your minor children. You've got those guardians appointed in your will as well. It just makes sure there's no surprises. And there was some very good advice from one of our aged senior partners from many years ago, who always said, never let your will be a surprise. If you're planning on treating children differently, not doing an even split of your estate, tell your children and tell them why. Because, as he said, it's a lot easier to have those conversations before you die, in all honesty, and it helps avoid conflicts. It helps avoid disputes in the future. A will can be flexible. We have this image of a will, or I have this image really of a will being sort of set in stone, being, written by monks and illuminated, and that's it. It's there. It says exactly who gets what, how much, and when. But it doesn't have to be. A lot of the wills I do, particularly where children are involved, are really flexible through the use of trust structures, and I'm going to talk a lot more about these. But you can use trusts in your will to protect assets for your children, to stop them being taken into account for welfare benefits purposes, to stop a child being influenced by a third party, particularly if they're vulnerable. You don't want them to have assets outright that they might give away, they might be conned out of. It can protect them from themselves. If you've got a beneficiary who spends all their time on eBay buying pointless plastic tat, then, the trustees of your will control that money. It can also be used to reduce inheritance tax as well. The current rules, I don't want to go into too much detail, but because it gets quite headachy. I envision my son again saying, "Daddy, you're making my brain hurt." But basically, inheritance tax is charged on the value of your estate that isn't going to charity or isn't going to a surviving spouse at 40% on everything over £325,000. But there is something called the residence nil rate band, that is an additional allowance of £175,000. Broadly speaking, spouses can leave £1 million in value tax-free to their children, either outright or on specific types of trust. And structuring your will correctly can help your executors take advantage of those tax laws at the time. I've just realised I've left a point on that. You can tell I've done these slides before. I've left a point on there at the bottom saying it might all change on 30th of October. We were coming up to the budget when I last presented. It hasn't all changed. There have been some changes in inheritance tax, but it hasn't affected these allowances. As I say, £325,000 standard allowance, a further £175,000 per individual where you have a property that's left to children, and that can be combined between spouses, say, to leave £1 million tax free. So don't want to dwell on inheritance tax. It is a complicated area. Very happy to talk in more detail and answer more questions as required. What if you don't have a will? Well, it's the opposite situation. There's no authority, it's uncertain, and there's no flexibility. So no one can really start acting in the estate until a grant of administration is given. The individual's personally liable for debts they incur prior to that grant. And if there's minor children involved, someone is actually going to have to apply to the court for parental responsibility. You've got no guardianship appointed under the wills. It's uncertain because it's statute that decides how your estate's distributed, and not all assets pass automatically to a spouse. This is a common misconception that things like pension funds or insurance benefits automatically go to the surviving spouse. Not necessarily. It depends on the terms of the pension scheme. It depends on the ownership of the asset. Really importantly, who is going to look after the assets for a disabled child? If you've got a sole child, an only child who's disabled, you both die, you haven't got wills in place, technically it's that child who can apply for the grant of administration. But if they've not got capacity, someone, maybe a local authority, is doing it for them, and the local authority is looking after the money for that child. There's no flexibility either. You know, if you haven't got a will, your assets pass outright potentially to your children. If they've been declared bankrupt, if they're going through a divorce, or if they're on state benefits, that money's gone, in effect. Minor children inherit at the age of 18. I dread to think of my children inheriting at the age of 18, to be honest. They won't have a clue what to spend the money on, or they'll spend it on all the wrong things. And you might have an unnecessary inheritance tax bill. So I definitely encourage those of you who haven't got wills, or even those who do, dust them off, make sure they're doing the right thing, and make sure you've got one in place, because it's so valuable where you've got a child with extra needs. I said I'd talk about trusts, so I'm going to. Trusts are a legal concept, which I will try and break down as simply as possible. Anything you own, and commonly we think about a house here, but anything you own has two types of ownership. The legal ownership, that's whose name is on the title, who is named on the title deeds, or whose name is on the bank account. They are the trustee of that asset. And they have the responsibility of buying or selling the property, deciding how to invest the money. They have that the ability to do the stuff with the trust assets. Next to that, or under that, you've got the beneficial ownership, the beneficiaries. They are the people who are actually entitled to the benefit of the asset. So the most simple example is a nominee bank account for a child. You are the trustee of that account, but it's the child who's entitled to the money. And at age 18, they can turn around to you and say, Mum, Dad, you know that nominee account that's in your name? You've got to hand it over to me now. And they can require you to do that. And then they become trustee and beneficiary. I've seen a few questions pop up in the chat. Yeah, they're very good questions. I'm going to come on to those towards the end, so I haven't missed them. But thank you. Do keep them coming. You will hear a lot of different terms potentially about trusts. You may hear things like pension trusts, spousal bypass trusts, will trusts, disabled persons interest trusts, investment trusts, bear trusts, all this stuff. You'll hear all these different names. The thing I always try and encourage people to do is just to bring it back, kind of ignore the name on the tin and bring it back to the fact that there are only ever 3 types of interest that someone can have under a trust. There is a bare trust, and this is where the beneficiary is absolutely entitled to the trust assets. It's a very simple trust. Someone else's name is on the bank account or on the house, but the beneficiary effectively owns it. They are the person who's entitled to live in that house or entitled to the money in the account. Very basic type of trust. At the other end of the scale, you've got a discretionary trust, where again, you've got trustees named on the property or whatever it might be, and a list of beneficiaries. And none of those beneficiaries have any right to the trust property. They've only got a hope that the trustees might give them something from the trust fund. And then you've got a middle ground, this life interest. And that's where you have a beneficiary who is entitled to income from the trust. And where it's a property, they'd be entitled to live in the house, but they aren't entitled to the capital value. So if the house was sold, they wouldn't be given the sale proceeds. They might be entitled to the income from those sale proceeds. So the house is sold, it's invested in stocks and shares, whatever, and they receive the dividends. And then after their life interest comes to an end, you've got the remainder beneficiary who receives the capital. And commonly a life interest is for life. So you might say, I leave my estate to my spouse for their lifetime after I die. Then after they die, it doesn't matter what their will says, it comes back to my children. The spouse is the life tenant, the children are the remainder beneficiaries. So it's a useful structure to try and protect assets from any claims on a surviving spouse's estate. And commonly we do that where care fees are a worry, to be honest. So, you know, if you die and you think, oh goodness, my spouse is going to go into care and the entire estate's going to be sold to pay for care fees, you can use this trust structure to ensure that at least half the estate is protected to pass down to your children. Trusts have a lot of advantages. As I say, with the life interest and discretionary trust, you're keeping assets out of the beneficiary's estate. It means the trustees control those assets. If the individual lacks capacity, as I said before, you know, if they're a spendthrift, the trustees can stop them doing it. You can preserve assets, protect assets against the trust assets against a claim for care fees. Also, as those assets don't form part of the beneficiary estate, they're not taken into account for a financial assessment for state benefits. They can also help protect from claims on the beneficiary's estate. So again, if the beneficiary only has that right to income or only has this discretionary right, because it's not their asset, it shouldn't be taken into account on a divorce or bankruptcy. I do say that the court has a lot of powers in divorce, and the family court can look behind trusts, but they at least offer a layer of protection. And say trusts are very flexible. The trustees get to decide what should happen with those assets, how they can best be used for the beneficiary. And really importantly, you don't need the court involvement. You don't need a deputy. You've chosen your trustees. They are the ones taking the decision for you, the people you trust. The clue is in the name, trust, trustee. There's no such thing as a free lunch. Trusts do have disadvantages. They need to be administered properly. So there's paperwork involved. Your trustees need to record their decisions, maybe by way of a deed, maybe in a resolution, or by email, but it needs to be done properly. They need to comply with the terms of the trust, so they can't do anything that the trust doesn't allow them to do. So, for example, they couldn't give trust assets to someone who is not a beneficiary. They should have regular meetings to say, this is what we're deciding to do with the trust and this is why. So they should document those meetings. They also need to complete tax returns. A trust is a separate entity for tax purposes, and they suffer quite punitive tax rates, which I'll come on to. There's a potential conflict. If a trustee is also a beneficiary, how do they make that decision? And the key thing is to say that the choice of trustees is absolutely key there. Is it someone who can act impartially? And there's a cost as well, possibly accountants or legal fees of running that trust properly. There's no reason why you can't have lay trustees. If they feel confident to do it all themselves, great. But generally speaking, people will need some legal or accountancy advice during the lifetime of that trust. Tax-wise, yes, trusts suffer punitive tax rates. Income tax is at 45% and 39% for dividends. So any income received by that trust is going to get very heavily taxed. For capital gains tax purposes, if a trust asset is sold, then you're paying tax at higher rates, and you only got half the annual allowance that individuals would have. But where you have a vulnerable beneficiary, and by that I mean an individual who's unable to manage their property and financial affairs because of mental capacity, or they're in receipt of certain benefits, things like universal credit, PIP, that sort of thing, or they're a bereaved minor, and by that I mean someone who's under 18 who's lost both parents, the trustees can make what's called a vulnerable beneficiary election, where they say, we, the trustees, elect to pay tax at the beneficiary's marginal rate. So you're not paying those punitive 45% tax rates. You're paying the rate at whatever the beneficiary would have paid at. And usually with a child, they're going to be a non or 20% taxpayer. Inheritance tax. You get inheritance tax during the lifetime of the trust, not just on death. Trusts have to pay inheritance tax at 6% or up to 6% when assets leave the trust, and every 10 years. But again, where you have a disabled child, someone who can't manage their finances due to mental capacity or are on those benefits I've mentioned, you can make what's called a disabled person's interest trust and not suffer those inheritance tax charges. Instead, the trust is treated for inheritance tax purposes as the individuals, so it's not taxed until they die. So in effect, where you have a disabled child as a beneficiary of the trust, provided the trust meets the relevant terms, for tax purposes, it's effectively their money, but it's still protected for benefits, for care fees, for divorce, for spendthriftness, everything I've just said. But for tax, effectively, it's theirs. The real important thing about trusts is you've got to do it properly. You've got to make sure the trust document has sufficient powers to enable your trustees to take any decision they need to in the future. The trustees need to exercise those powers properly, record them properly. They need to comply with their duties. They need to document what they're doing. They need to do their tax reports. They need to keep accounts. There's quite a lot of work involved. So you really need to think carefully, who do I want to burden with this at the end of the day? I've mentioned this from the context of will trust. So the idea, when you die, your estate drops into a trust for the benefit of your children, and it sits there for the rest of their lives. But you can set up a trust during your lifetime. The terms of the trust are identical to everything I've been talking about before. It can be a bare trust, life interest, discretionary, or disabled person's trust, something like that. The objectives, the advantage and disadvantage are exactly the same. But the advantage about doing a lifetime trust is it can capture assets that don't pass under your will. As I said earlier, people often think, oh, everything I own goes under my will. But things like pension funds don't, death in service doesn't pass under your will. Gifts to your child from third parties. You don't want a third party giving assets outright to your child during their lifetime or under their own will, because again, it messes up their benefits. It needs a deputy or attorney to look after it. Instead, you can set up a lifetime trust that's kind of like a piggy bank, where you can say to the pension company, when I die, put the funds into that piggy bank, into that trust. You can say to the third party, under your will, give the assets to this trust. Don't give them outright to my son or daughter. Put them in this trust, please. So you set it up in your lifetime. It holds an initial £10 and it's there kind of as a bucket or a piggy bank ready to receive money from other sources. But say all the other considerations I've mentioned so far about will trusts apply to lifetime trusts as well. And again, it helps avoid that need for an attorney or deputyship, because any money you want your child to benefit from goes into that trust. I hope that's clear so far. I'm conscious about 10:02. I was going to run through a quick case study, which may, I hope, answer some of the questions that have popped up in the chat and bring some of what I've said to life, really. So, set out some background here. We've got Mr. and Mrs. Scratchett. If you're a Blackadder fan, you'll recognise those names. I grew up with Blackadder. They are in their 60s. Mr. Scratchett himself owns a property that's worth about 300,000, and he's got savings in ISAs and things like that over the years, 250,000. Mrs. Scratchett, as often used to be the case, you know, she was looking after the children and everything, and she's got her savings worth 50,000. They've got 3 children. They've got Bob, 16, Harry, 21, and Pat, who is 25. Bob's in full-time education. He has special educational needs. Harry sadly suffered a brain injury as a child and is mentally incapable of managing his own finances. And Pat, though, is capable. She's a successful business owner. There's the family. So what happens if they do it the wrong way? So they haven't made wills. Mr. and Mrs. Scratchett don't make wills. Sadly, they both fall very ill. Mr. Scratchett dies first, and then 20 days later, sadly, his wife dies. So to inherit under the intestacy rules, where there's no will, a spouse has to survive at least 28 days. And that's not happened here. So Mr. Scratchett's estate is passing straight down to the children, and Mrs. Scratchett's is passing straight down to children as well. So this means that for inheritance tax purposes, Mr. Scratchett's nil rate band, that £325,000 allowance, is set against his estate, and Mrs. Scratchett's allowance is set against her estate. There's a shortfall of inheritance tax allowance for Mr. Scratchett's estate. There's 20-odd thousand pounds of inheritance tax to pay, because there's not enough allowance from his estate alone to cover what he owns. The rest of the estate passes equally to the 3 children. It's about £190,000 each after tax. So what happens to each of them? We've got Bob. His needs aren't actually too bad. By the age of 18, he's able to live independently and manage his finances, but he is still young. He's inherited £190,000 at age 18. He doesn't see a benefit in property ownership, so he just rents with his friends. He's easily influenced. He's vulnerable. He meets a girl and they start to rent a property together, but she sees, you know, the dollar signs prop up in her eyes. She sees he's got a lot of money, encourages her to buy expensive gifts and holidays, and before long, he runs out of money and has to move into state-funded accommodation. He loses all faith in relationships and ends up as a lonely bachelor. Poor Bob. What about Harry? Well, he's got full-time care, but his health needs are not sufficient to qualify for NHS CHC funding. I'm happy to answer questions about that, but basically that's where you get free funding from the NHS. As a result, he gets local authority means-tested funding. He's got more than £23,000 in the bank now. He's got £190,000, so the local authority don't pay for any of his care. He has to fund it himself. He's also unable to manage his finances, and Pat's too busy with her business, so the local authority applied to be his deputy to manage that money. Relatively swiftly, the care fees eat up that inheritance, and he's reliant on local authority care for the rest of his life. So Harry's got no money left. What about Pat? Well, Pat uses the money, pays off her mortgage, invests the balance in her business. But before her parents died, she was helping look after them. As a result, her business had suffered. She uses some of the money to prop it up, but it still isn't enough. So she files, sadly, for bankruptcy. She's forced to sell her property and settle the business debts and has little money left, so seeks employment. Pretty dismal story there. Now, I will say, not all of this has happened to clients of mine, but this is actually taken from various clients' cases over the years, and these various things have happened. So what happens if Mr. and Mrs. Scratchett came to me and we talked it through and we did wills for them, doing it the right way? So what they do is they make wills, they leave their estates to each other, and then on the second death, they leave their estates to a discretionary trust. And by way of reminder, that's where none of the beneficiaries have any right to the trust assets. Their executors, their trustees are looking after that money. So on the first death, we've got spousal exemption, no inheritance tax to pay on the first death. And then because everything's passing through Mrs. Scratchett's estate, she can benefit from Mr. Scratchett's allowance. You've got that £1 million tax allowance, no inheritance tax to pay at all. They appoint Alice as executor, but appreciate, she may need some assistance, so also appoint a professional trustee alongside her. And they leave letters of wishes, letters of guidance to the trustees, saying what they would like to happen is they would like a third of the fund to be kept in trust until Bob is financially mature. They want a third of the fund to be used to help Harry with his care needs, and a third of the fund to be given to Alice outright if she wants it. So how does this change things? Well, as I said, Bob's condition's not too bad. By age 18, able to live independently. He's still young, though. He still doesn't see the benefits in property ownership, and he wants to rent with his friends. So the trustees invest the trust money and give him an income to pay the rent. He meets the girlfriend again. She's trying to convince him to buy those expensive and nice gifts. But the trustees say no. They're not handing over vast sums of capital to pay for expensive holidays and gifts. She sees it's not a gold mine, so leaves. He then meets Wendy. They set up a very nice home together, and they get married. And the trustees go, well, he's financially mature. He's secure in his life now. We're going to wind up his share of the trust and give him the rest of the money outright. And he lives happily ever after. Brilliant. Harry, still in full-time care, still needs help from the local authority. But this time, his third of the estate doesn't belong to him. It's held in trust. So the local authority, social services, pay towards his care needs. The trustees can use that money in the trust to help pay for things he really enjoys. So they pay for holidays and specially adapted accommodation. None of that's being taken into account for his care needs. Social services still need to pay for his basic care. There's still money left in the trust on his death, and then the trustees wind that up and give the assets outright to Pat and Bob. So Harry's been well taken care of using the trust fund. Coming back to Pat as well, she knows her business in jeopardy. She asks her co-trustees to give her funds. The trustees think, actually, it's a bit risky. We're not going to give you the funds. Sadly, she still has to file for bankruptcy and loses her house. But those assets sitting in the trust weren't taken into account in the bankruptcy proceedings because they don't belong to her. The trust lends her some money to start a new business, and that goes very well. She repays the debt to the trust. And then she says, well, actually, there's still money sitting in the trust. I don't want to receive it outright. If I do, when I die, there's an inheritance tax issue. So she asks the trustees to pass the money on to her children, paying for their school fees and university and so forth, skipping a generation for inheritance tax purposes, because it's nice and flexible. Hopefully that case study, as I say, it seems totally out there, but these are things that have happened to clients along the years. It shows the benefits of those flexible trusts under your wills. The key thing is, I must say, in all of this, be prepared. We don't know when there's that bus around the corner with our name on it. We don't know what's going to happen with our children in the future. Will they have capacity? Won't they? Having a flexible will in place, setting up that trust in your lifetime, ready to receive assets from third parties, is so helpful. It does away with deputyship. It does away with powers of attorney. You know who's looking after that money, and it's not affecting their benefits. Really, really important. I hope that's been helpful. I've seen there's a lot of questions that have cropped up there. It is a big, complicated area, so I can talk for days on this and happily would. But hopefully that's given you a bit of guidance along the way. So Kate, as I see the questions in, I'm conscious it is hitting 12. I'm happy to sort of pick the questions out and answer them if that's all right.
That would be great. That would be great, Stuart, if we could do that. I'm just going to stop the recording now. As long as the questions stay anonymous, that's okay. So I think if we go back to 11:31 in the questions, the one I spotted, hang on a minute, I can't, where are we?
So I've got, how do I ensure that in the future when my child inherits the house isn't sold? Yeah.
Yeah.
Well, hopefully that's something I sort of addressed in that case study. But let's say anything that you leave outright to your child or to your surviving spouse could be attacked, could be claimed by social services to pay for care fees. So whether that's the surviving spouse's care fees or your child's care fees, if they own it outright, it's up for grabs. Using that trust structure, that life interest or discretionary trust structure, the spouse, the child, doesn't have the outright right to the capital value of the property. So it's there to be protected, but the trustees can use it. If the house needs to be sold, they can use that money to buy them a better level of care, to buy them those pieces of equipment they might need, or to pay for those holidays, as say in the case of Harry and Bob. I'll just carry on scrolling down if that's all right, Kate,
Okay.
and pick them up. So we've got, is a trust a specific bank account? No, a trust itself is can be over anything. It can be over an account, it can be over a property, it can be over personal belongings. Basically, a trust is sort of like a piggy bank that anything can go into with the trustees managing it. You will find, though, if you have, so let's take a common situation where a house is left on trust for a surviving spouse or for a child, and you leave some cash to the trustees to help fund repairs to the house or something like that. Where do the trustees put that money? And yes, they would, like anyone, put it in a bank account. The problem is it's really hard to open a trust bank account nowadays. There's only a couple of financial institutions. I think Metro Bank and Cater, I think, are maybe the only banks that are offering trust bank accounts at the moment. So yeah, trustees have to be a little bit creative as to where they keep the money. They could keep it in a personal joint account and run it as a trust account. So there are some administrative challenges there, but no, a trust just isn't solely over an account. It can be over any assets. Can a trustee be a power of attorney? Yes, absolutely. They can take on both roles. They are entirely separate, though. The attorney is looking after the individual's personal assets, the assets they own in their own name. The trustee is looking after the assets in a trust. And it's very common to have both. Because it may be, as I've touched on in the presentation, it may be the individual has their own money. A common situation is maybe some of you have set up child trust funds. And I have a bit of a bugbear with child trust funds, unfortunately, because they're a great concept. Save money for your children for the future. They're tax advantageous, great. But no thought, I think, was given by the government to when the child turns 18, that is their money, and it's available to assess for benefits purposes. And if they haven't got capacity, they can't access that money. So a deputship is required to get access to that child trust fund. So, if they've got capacity, they may have appointed an attorney to look after that child trust fund, but any money you leave them under your will can be in the trust, and the attorney and the trustee can be the same person. So I hope that answers that question there. Can a power of attorney be the will writer and trustee for the trust, executor of the will? So yes, they can be a trustee for the trust. Yes, they can be executor for the will, and yes, they can be the power of attorney. They should not be the will writer, the person writing the will for you. There is a presumption that where a will is written for someone, and it's basically written by a beneficiary, that there was some sort of undue influence, some influence over that will. So the will could quite easily be challenged. I'd strongly recommend you get an independent third party to write and advise on the will. If you're doing a trust structure on your will, definitely get expert advice. As I sort of mentioned, you need to make sure all the provisions and powers and everything are in there, and it's structured properly to take advantage of those tax advantages I mentioned, and to make sure it does its job. It's so easy to put a will and say, to be held in trust for my child. Well, actually, what does that mean? Is it a bare trust? Is it a life interest? Is it discretionary? So yeah, definitely take professional advice on that. But otherwise, yes, they can be the trustee, they can be the executive, they can be the attorney. Just bear in mind there might be potential conflict there in the future. A bit of a detailed question here as well. Own property, son's 12, has additional needs. Anything happens to me, don't want his father, someone moving the property. Would a trust help with this? Father would end up as main carer. Someone be led by anything. Yeah. So absolutely. In your will, and I'm assuming you don't own the property jointly. I will talk about that if you do, but assuming it's your property, ex-husband doesn't have any right to it. Yeah, put it in a trust for your child. Appoint people you trust as the trustees. They will become the legal owners of that property. They get to say who lives in it. The terms of the trust would say your son has the right to live in that property. In terms of practical considerations of providing care, I mean, yeah, maybe the trustees might have to, let ex-husband come in to provide that care, or maybe if there's other funds available, they look to buy in care from third parties. But yeah, the trust would say, no, this is your son's property. Would ex-husband have a claim on your estate? It is possible for a spouse, a partner, someone who's financially dependent, or even potentially an ex-spouse to bring a claim against your estate after you've died. The key thing there is if you've got a divorce order, or if you've got the final order from the divorce court, to make sure it says ex-spouse can't bring a claim on the estate. That way you make sure the assets are protected. They can pass into the trust with no problem. Where you own a property jointly, and this applies beyond the specific question, where you own a property jointly, there's two types of ownership. There's what's called joint tenants and tenants in common. And 90% of people I say, how do you own your property, joint tenants, tenants in common, have no idea. And that's fine. That's fine. The default position tends to be owned as joint tenants, and unhelpfully you will not find anywhere written on the title register of your property whether you hold it as joint tenants or tenants in common. There's what's called a restriction on the title if you hold it as tenants in common. And you may say, why on earth are you making a big fuss about this, Stuart? What's the difference between tenants in common and joint tenants? Where you own assets as joint tenants, the property, the bank account, whatever it might be, automatically passes to the survivor, whether you're divorced or not. It doesn't matter what your will says. So if you own a property as joint tenants, say I leave my entire estate into trust, that property is going to the surviving owner. It won't pass into the trust. So it's really important to make sure if you set a trust structure up under your will that you own the property as tenants in common. That makes sure your specific share of the property will pass into the trust under your will. It is absolutely possible to convert a joint tenancy to a tenancy in common. I hope that's addressed that query. And Kate, do please stop me if we're running short of time, but I'm happy to keep going. Can I set a trust up will say inherit through a trust at age 25 instead of 18? Yes, with a set amount appointed each month. Broadly speaking, yes. You could set up this life interests, which guarantees them an income. You can get very specific in your will and say at age 18 they get 50 quid a month, then up to 100, then 500, whatever. In that scenario, I'd actually encourage you probably to do a discretionary will. Say to your trustees, I'd like them to have this amount when they're 18 and so forth until 25. With that discretionary structure, if something untoward is happening in their lives at age 25, they're getting divorced or suddenly on benefits, the trustees have the option actually to say, we're not going to give you anything yet. We said, your mum and dad wanted you to have the assets at 25. We're going to keep them in the trust until that bankruptcy has passed, and then hand the money over to them. Is a discretionary trust the best one for special needs children? Depends on circumstances, in all honesty, and I'm afraid that's a very lawyer answer. It depends. You can have what's called a discretionary disabled persons trust, and what that is a trust where the special educational needs child doesn't have access to the funds. It's up to the trustees to decide what to pass to the beneficiary, but it has the tax advantages I was talking about earlier. This no inheritance tax charge. So yeah, it very much depends, and say something I'd be very happy to chat through and decide what is the best structure? And that's where professional advice really helps. What is the best structure for your circumstances? And that's similar answer to the second question. What's the best structure for your children? One has special education needs, one doesn't. Yeah, probably a discretionary structure, but it also depends on your aims. If you're happy for your able child, if that's the phrase I can use, to have assets outright, you could split your estate in half going outright to them, half into a trust for your child with needs. Who or what is a professional trustee? So a professional trustee is an individual who, it doesn't have to be an individual, it can be an organisation that is qualified to provide trust advice. Normally it'd be something like a bank, a solicitor, or an accountant. It is someone who has the professional knowledge of the legal and tax side to manage the trust properly. We have what we call a trust corporation, which is a company that can act as a trustee. The advantage about appointing a trust corporation is it's never going to die. It's never going to retire. So you have sort of continuity of a trustee all the way through, and it's absolutely fine. Have a lay trustee, a family member may be acting alongside a professional. The professional handles the tax and complicated legal stuff. The family member handles all the really important day-to-day decisions. What care does the individual need? What do they need on a day-to-day basis in terms of food and equipment and so forth? Does the money in trust affect entitlement to benefits? Depending on the trust, no. So if you've got that discretionary trust or discretionary disabled person's trust, no, because the trust money doesn't belong to the individual, so it doesn't affect their entitlement to benefits. If you have a bare trust, it will. It's their money in effect, just someone else's name on the tin. If you've got a life interest, the capital shouldn't be taken into account, the capital value of the trust, but the income will be because it belongs to them. Gosh, lots of questions. If a child already has money in savings with parents as a trustee, can these be put in trust, or does it transfer to them aged 18? Presumably they need to look at power of attorney. Yeah, a really annoying one. So if it's a nominee bank account where it's the parent's name on the account, but the money belongs to the child, it has to be the child's decision to put it into a trust. And if they don't have capacity to do that, then you're right. You're looking probably at a deputy, or if they've got capacity to appoint an attorney, you're looking at an attorney to manage that money. The problem is an attorney or deputy cannot give away the individual's assets to a trust. It's making a gift. It's putting the money beyond their reach if you try and put it into a life interest or a discretionary trust, and that would need permission from the court. The other disadvantage about it as well is the benefits office are going to turn around and say, well, you're deliberately depriving them of funds, so we are taking that money into account. So if the individual got, say, £10,000 in their bank account, and you as attorney or parent or whatever say we're taking that money away from them, putting it into a discretionary trust, putting it beyond their reach, the benefits office will say, no, we're treating it still as their money. And this is where I have the problem with child trust funds. It was an encouragement to set up funds for them. But it's, when they hit 18, it's their money to be taken into account. And I think that probably answers the same question about junior cash ISA. It's his money, only he could decide to put it into a trust. If he's got an attorney or deputy, they would need court permission to do it. Can any solicitor set up these trusts? Any solicitor worth their salt. Sounds rather smug, sorry, I shouldn't say it like that. Yes, technically any solicitor can, well, to be honest, anyone can set up a trust. It doesn't have to be a solicitor. But what I'd hugely recommend, if you are consulting with a solicitor, make sure they've got the specialist expertise in benefits and disabled persons interest trusts. They are a very specialist area, so I've been doing it for so many years. If possible, make sure they are what's called a member of STEP, the Society of Trusts and Estates Practitioners. STEP members like myself have specialist training in estate planning and tax. So I'd commend asking if they're a STEP member. But technically, any solicitor should be able to do it if they've got that specialist knowledge. I think we've got one question at the end here. If my daughter were to be the disabled trust holder for my disabled son, would this mean that technically the money is hers? No, a trustee, money held in a trust belongs to the trust, depending on the terms of trust. If it's a discretionary trust, it's the trust money. It isn't taken into account for the trustee's personal circumstances. So I hope that answers that question there. Well, I think that's everyone, Kate. Has everyone
Yeah, I think that there might have been a couple of little ones that was missed. Somebody asked if they could set a will that somebody would inherit from the age of 25 with a set amount appointed each month of.
Oh, yeah, that's why I was suggesting we should have maybe a
Oh
discretionary
yeah, okay, I
trust
do
under the
apologise.
although I did just see what happens if you are a single parent.
Yes.
That's quite a wide-ranging question. I didn't avoid it, I promise. I didn't spot it. Well, it very much depends. I mean, certainly I would say, if we're looking after death, yeah, go with that trust structure under your will, appointing people you trust to look after the money after your death. If you haven't got anyone, consider a professional trustee. This firm's got lots of experience in looking after vulnerable adults. During your lifetime, well, yes, if you can get a health and welfare and financial power of attorney, they're worth doing if your child's got the ability to do that. Otherwise, yeah, maybe you're looking at applying for deputyship there. I say that's quite a wide question. I'm not sure whether I'm hitting the mark there, but if you want to have a chat with me, do drop me an email. Very happy to answer any specific questions.
Okay, well, thank you so much, Stuart. What I would like to ask Zoe, if you could put the survey feedback in the chat. So just while I'm talking, but a huge thank you for everybody that's joined on today's session. And an absolute wonderful thank you to Stuart for his amazing knowledge and experience and giving his time today. Stuart has also offered to support by email or even a sort of non-obligation chat. So if you would like that, just let me know and I will send you Stuart's email and contact details. And after this chat, we'll arrange to get this recorded on video on YouTube. It may take us a little while to get some subtitles, but we will do that. But a huge thank you to everybody. Also, I will send you email after this and a text. I'll probably put the survey in it again, just in case you don't get a chance to do it. But please do check your junk mail. And if you feel that this has been really beneficial, let us know in the survey. If there's anything that we may have missed, let us know that too. But thank you so much, everyone, for your time.